Hello, I'm Ross Downs. I'm an attorney licensed to practice law only in the states of Louisiana, Arkansas, and Mississippi. This video does not constitute legal advice. The video is for general informational purposes only. The viewing of the video does not establish any attorney-client relationship, nor is it intended to do so. And finally, we do not wish to represent anyone wanting legal representation in any states other than Louisiana, Arkansas, and Mississippi. And with that, today's topic that I wanted to discuss for general informational purposes is what questions will be asked in a deposition in a personal injury type case. And the short answer is a whole bunch of stuff. Typically, an injured party is going to be asked a series of background questions that have to do with the person's, of course, age, addresses, where they've lived, marital status, children, what type of educational history does the person have, the work history, all the places of employment, jobs, earning history, and the like. Additionally, the injured person is going to be asked about any prior accidents, prior injuries. Typically what we see is the person's going to be asked about any prior criminal convictions of any kind. And then typically the focus will be on the subject accident, what happened, or the subject event that caused the injury. You know, what happened, explain everything from A to Z as to what happened and what the individual remembers there, what injuries were caused by the accident, what medical treatment the person had, and then how was the person doing as of the present date, were the injuries temporary, permanent, and the like. What I often suggest to my clients, and I think is good advice, is the taking of a deposition is the person that's given the deposition is held to a standard that is not usual in everyday life. What I tell people is, imagine you're at the pearly gates. You're getting interviewed by Jesus. Jesus knows the answer to every single question Jesus asked. And oftentimes the defense counsel, they know the answer to everything they ask. What they're trying to do is catch the individual in inconsistent statements, factually incorrect statements. So if a person gives an answer to a question, the person needs to know that they're going to be held to that standard. And the questions themselves need to be very carefully listened to, because if the question is, have you ever been injured before? They mean from when you came out of your mama, however you came out. Have you had a paper cut? Have you had any kind of injury? And that's the ridiculous standard that you're held to, or at least that we see that people are held to. And now there's no way it's possible for anyone to remember every single injury they've ever had, but a person that's candid and forthright that they've had other injuries throughout living life, sprains, strains, and the like, oftentimes we see that does better than trying to deny that anyone's ever been hurt in their history, if in fact that's not true. So you want to be honest, you want to tell the truth, you want to lay it out there, you want to listen to everything that is asked very carefully, and understand that the other side is going to do a thorough and complete background check and probably know the answers to almost every question, if not every question that the deponent is going to be asked, particularly if it's the injured party. And lastly, if a question is asked that the person doesn't know the answer to, say you don't know, as opposed to guessing or speculating, because if you guess or speculate, it's going to almost always be able to be shown that that was an inaccurate or incomplete answer. So tell the truth, don't guess, don't speculate, and do the best you can with it, and understand what the other side is trying to do and accomplish through the use of the deposition. Thank you very much.